Good morning. The judgment which I am going to discuss may be very theoretical, little bit hard to understand unless and until you have similar cases. But for young lawyers and the persons who are approaching for examinations for APP and judicial officer, you must know the basic principles which has been discussed in the judgment. Number one, this is AIR 2024 Supreme Court 5731. AIR 2024 Supreme Court 5731. Madhya Pradesh Madhya Kshetra Vidyut Vitran Company Limited and others. Madhya Pradesh Madhya Kshetra Vidyut Vitran Company Limited and others versus Bapuna Alberia Private Limited and another. That is the appellant is in electricity board, Madhya Pradesh electricity board. Actually, what had happened, the respondent company had many number of contract for procuring electricity and supply electricity. All these things are facts of the cases. You have to go through it. You can understand. The question arises, which given cause of action to approach the court by the company was that he was initially served with a notice. So first show cause notice was served. He went to single court and single court initially granted interim order directing him to pay minimum guarantee amount. Then thereafter again some more problem arose. So thereafter what had happened, he withdrew the writ petition. Then the second show cause notice was served on him, claiming some revised tariff. That was also challenged. And the first writ petition was allowed, stating to minimize the amount. Accordingly, amount was minimized and the company was permitted to file, submit bank guarantee. And again, electricity board issued the show cause notice and working order and recovered the amount from bank guarantee and returned the amount. Then again, another show cause notice was served. The problem is all these things. If you want to concentrate on all this which I have read now, you go through the entirety judgment. For young lawyers and inviting lawyers to understand the provisions of law is that the main question raised by the company before the division bench was that the the second show cause notice was pertaining to the period before enactment and bringing force of Act 2003, Electricity Act 2003. The claim of the dispute was between 96 and May 2000. So it is prior to enforcement of Act. Therefore, under Section 56 Class 2 of the Electricity Act 2003, only within the period of 2 years, the claim may be claimed by the electricity board. But that was not available prior to the Electricity Act 2003. There was an earlier act did not contain that provision. So the problem now says that division bench holding that this since the bar of 56 class 3 2000 act as well as section 6 of the General Classes Act. General Classes Act says that if the act did not contain the provisions for retrospective effect, that may not be implemented too. But the Supreme Court has now the question Supreme Court has set aside the division bench order, which held that 56.2 was available. So on what ground? That is most important to understand. The Supreme Court has discussed what is the difference between res judicata and estoppel. Res judicata and estoppel. They have held, you go through the judgment, they have held that res judicata means there is a bar for the court to take cognizance or try for earlier for same cause of action between the same parties or constructive parties. The matter was already decided. That is called res judicata. Then what is estoppel? The estoppel as well as res judicata are of nature of principle of natural justice. But what is difference between estoppel and res judicata? Res judicata is a bar for the court, estoppel for the parties. If suppose party filing a different case and raising the same point which was earlier decided, so that party is estopped from raising that. In that way they have decided this issue and set aside the writ appellate court order. So I think you understand. At least you understand for this concept that there is what is difference between estoppel and res judicata, because that will be a single word questions being put to you. Multi number of judgments were discussed. But the judgments, if you want to apply in your practice, you try to apply that this is still hold good. Which is hold good? Section 66 of General Classes Act and Electricity Act 2003, which prohibits to take appropriate action within period of 2 years. And 1948 Electricity Act did not contain. Therefore, prior to 2003, the Electricity Board have no right to initiate proceedings after 2 years. So you try to understand that aspect, and you just have a knowledge of what is difference between res judicata and estoppel, and forget about this, and keep concentration of the judgment. This is AR 2024 Supreme Court 5731 Madhya Pradesh Madhya Kshetra Vidyut Vitran Company Limited others versus Bapuna Al Gobrew Private Limited other. Okay, happy Bogi.